This is part 2 of the Idaho 4 Moscow murders pretrial hearing roundup of what happened and my summarization of everything, because it was about 3 hours long and not the most interesting things happened, but I still want to bring it to you. If you have not seen part 1, please go watch that below before watching this one. So where we left off, we are now going to be talking about seating in the courtroom and broadcasting. Okay, so regarding the seating in the courtroom and broadcasting, each side will have 2 counsel tables put together that can fit about 4 to 6 people. A small table behind defense with additional staff members. Judge needs numbers of who will attend. Does not include families, just the staff. Reserve seating for victims agreed to by parties and for defense family 4 members. 2 other roommates are welcome as well, but feels that they won't attend based on how they were treated in the media. I thought that was a little bit too much of a personal statement, an opinion statement from the judge, but he made it anyway. So he believes that they are victims. He even said so. That's subjective. They said they will make the additional seating available to outside parties if those people don't come that day for the defense or the prosecution. Those seats will be made available in the gallery. He said weekly each party will notify court if they will be using all their seats every day or not, and then there will be a website that you have to go to in order to get a seat in the courtroom, and then you'll have to bring your ID and prove who you are. The stream will be allowed, but it's going to be controlled by the courtroom and run on the court's website like normal. Views will be the podium, bench, witness stand, and counsel table. Static views, no zooming, etc. Victim witness coordinators on state side, at least 2, and 1 extra person for BK's family to help with the media will be admitted. Asked if certain law enforcement, the roommates, and additional people who are sensitive to their images being broadcasted. Judge again states he believes the roommates are victims. Again, said will be seen. That's not for him to say. He's already creating bias, but that I digress. State and defense agreed multiple people may need their cameras shut off while they testify. Judge grants for the roommates, but for the covert operations of law enforcement, their camera may need to be on, and he will talk about it with them, but anyone else, he will need to be really convinced because there is a public right to know. And then there's opening statements. He said he's not tolerant of arguments during open statements. Meaning between the 2 parties, like the prosecution and defense. He said that both need to submit the time request for how long their opening statements will be, and the judge will give depending on that request. Important to share items 72 hours in advance and lodge objections 48 hours in advance. If you haven't heard back, he expects to have you to have 2 different versions of your opening statement, one with whatever you're trying to have admitted and whatever he might object to. I mean, having it without it is what I mean, like with and without. He also said that if the counsel wants to show something and they put the lights off for it, that the lights are going to remain off for their entire opening statement. So he said plan accordingly. We're not going to turn the lights on and off constantly. Now, as far as witnesses, affidavits need to be given to the court. Defense asked about phase 2, only witnesses, still having to do the same thing as phase 1, I'm assuming, because, again, there was a glitch, and so I didn't see some of it, but about halfway point, that's where that glitch occurred. Having witnesses be questioned by both sides of different parts of the investigation so they don't have to go back and forth multiple times. State advice to make sure the witness is still available. And he said if they don't tell defense and let the witness go, he threatened striking the entire testimony of said law enforcement official. Judge wants everything in writing. So for objections during trial, he said that he just wants no argument. Like if they object and they say object, hearsay, that's all it should be. He says he tends to order right away on the spot. And if they need to make further record asked to approach, do not argue in front of the jury. Physical barriers will be there to block the jury from seeing what they are discussing, and doesn't want to excuse jury if they can avoid it. Thompson asked about objections to the motion in limine being done outside the presence of the jury. The judge basically said if I've already ruled on it, there's no need to bring that up again, but he said if you need something to be reconsidered, we will do it outside of the presence of the jury, i.e. like the model home is still in contention. Now, he was very clear about that they do not make accusations against opposing counsels, do not talk to each other directly, especially in front of the jury. He referenced, I think he was referencing when Syray made the accusations of the prosecution doing things unethically, and he said that Syray didn't prove this in his statement, but he also didn't let Syray talk to him directly and come that day. So I don't understand why he's making a big deal about it, but then also didn't let Syray defend himself or talk about the issue at hand. Now we're on to exhibits. He said people who need to authenticate things need to be done under subpoena just in case. So he's saying if people are going to testify, they need to be under subpoena orders. Projector or litigation software to present the exhibits. At 2:25, it also froze again, the third time, writing which is phase 1 and phase 2 exhibit spreadsheets, and judge will review all the exhibits from now until trial. Now, jury instructions. Will instruct it's a capital case. You will have to decide if you find the defendant guilty. You will have to decide his punishment, but there are other instructions saying that you don't look at that during the guilt phase of trial. Any guilty verdicts will start penalty phase 2 right away. Jury will be sequestered during this process. Now, if aggravating factors are found, judges' options are limited to life without parole or death penalty. Declaration, last best offer given to defense, and he would want to know if the defendant received this said offer and did he accept it or not. Then they talked about transcripts and if they want it real time, daily, or no transcript. And then he explained that there are separate fees if they want both, and that Anne asked if she can make the decision closer to. Real time would need to know in advance so that the court can provide it. Court only supplied software but not the hardware, so if they want that, they need to bring tablets if they want the real time transcript. Then there was talk of the sequestration of the jury, meaning that they are not allowed to go home, in essence. And no, they're not going to start with sequestration. And the defense asked that the sequestration be a part of the voir dire process so that the jury members know it's a possibility that's going to happen eventually, and so that there's no problems later on. And the very last part was the violation of the non-dissemination order. I don't know. I have to see when that happened with the Dateline episode because I don't think it happened yet at that point, or maybe it was the same day. But he talked about like there being a special magistrate or prosecutor requested, and then a magistrate will be able to grant immunity, or I didn't really understand that part. It was kind of vague and quick. So if you guys understand that part, let me know. I will be sure to try to post that on my YouTube. So you guys can watch it in full. I want to try to find a different recording because the one I watched was cut off a couple times. So I want to see if I can find one that's a little bit more clear and full. But if you guys like that, make sure you give a like and a follow. I try to summarize things that I watch. I've worked through the motion in limine. The last parts are coming on my YouTube channel. If you have not seen that, motion in limine is basically what they're going to preclude from coming to trial. And so they argue about the different things, i.e. like the model that they made of the home. Can they have that at trial or not? So those are the things they were arguing about. I separated it into the different parts because it was 8 hours of testimony. It's a lot. So if you guys have not seen that and want to see that, you can go little by little each day and watch one of my videos. I definitely need help building that audience over there. So if you guys want to check it out, please do. Otherwise, thank you for watching and I appreciate you following. Make sure you give a like and a follow.